In this video, we're going to be discussing powers of attorney and why it is such an important document for Medicaid planning. And one of the first things that I want to get out of the way is a lot of people think that the durable power of attorney is a one-size-fits-all document. They go on one of these internet sites, they pay 50 bucks or 100 bucks or whatever it is, and they download this form document and they go, okay, good, I've done my job, I now have my power of attorney in place. And that's not entirely true. In fact, durable powers of attorney have to be very specifically drafted for Medicaid planning purposes or elder law purposes because of the fact that there's just no such thing as a general durable power of attorney. You can't just say, here, I want this person to be able to do whatever they want. You have to very specifically describe what it is you're giving them the authority to do. And most estate planning attorneys and form documents found on the internet, they're not adequate. They're just not adequate. And that's not to cast dispersions on estate planning attorneys. That you come to them for a very specific purpose, and they put together typically a fine document for that purpose. But the durable power of attorney in a Medicaid planning context, or what an elder law attorney needs to do their job successfully, typically will require language that an estate planning attorney won't put in their document because it's not their job. And the second reason, and of course, if it's a form document that you just online, I can almost guarantee that it's not going to be adequate. So these are very important things to take into consideration. If it's been some time since you have signed your durable power of attorney, I would highly suggest you have it reviewed by an elder law attorney to make sure that if you ever get to the point where you can't act for yourself and you need to apply for government benefits, sometimes you want the agent or the attorney, in fact, who holds the power of attorney to be able to self-deal. You want to make sure that the document gives them the ability to do that. Otherwise, you may be put into a situation where if you become incapacitated, no attorney will be able to help you because the power of attorney document is just not sufficient for those purposes. Then your option is you have to institute a guardianship proceeding, and that is needlessly expensive. So people think to themselves, well, I'm nervous about signing this power of attorney with very, very significant powers to my agent. I would say, better for you to pick the person to act on your behalf than the judge, at least in most cases.